A will creates a trust if it states that property must be used in a certain way for identifiable beneficiaries. But does a will still create a trust if it states only that a beneficiary should use property in a certain way? The Virginia Supreme Court addressed this question in Spicer v. Wright. Leila and Meade Spicer were married. Leila was very close with her sister, Anne Wilson. 2 years before Leila died, she handwrote a holographic will that named Anne the executor of Leila's estate. The will also gave Leila's entire estate to Anne, quote, to be disposed of as already agreed between us, unquote. But the will didn't explain what that phrase meant. When Leila died, Meade and Anne were still alive. However, before Leila's will was probated, Anne died. A new executor, Russell Wright, was appointed to distribute Leila's estate. Wright petitioned to have the circuit court determine whether Leila's will gave her property to Anne in fee simple for Anne's own use or in trust for unknown beneficiaries. If the will created a trust, it was undisputed that the trust would fail for indefiniteness, and the property would stay in Leila's estate, going to Leila's closest heir, her husband, Meade. The circuit court ruled that the will's bequest used precatory language, which meant it stated a non-binding wish or desire for Anne to use the money in a certain way. Evidence was submitted that Meade had mental health issues and Leila controlled Meade's assets. Anne had told her employer that she was helping Leila prepare a will relating to Leila's, Meade's, and Anne's property. The sisters had used the same maid for 40 years, and the sisters didn't want distant relatives to have their property. The circuit court determined that this evidence didn't show that Leila was trying to create a trust, and therefore that the will gave Leila's entire estate to Anne personally. Thus, Leila's property was part of Anne's estate, to be distributed to Anne's beneficiaries. Meade appealed to the Virginia Supreme Court. Meade died while the appeal was pending, and his estate continued the appeal on his behalf.